Greetings everyone. How's everyone? Hope you guys are good. I'm good, guys. Welcome to the platform, The Labor Lens. We are back with another episode. Today we are doing the Unfair Dismissal Award reviewed, Procedural Unfairness upheld, right? But before we get to it, please guys, go to the subscribe option, click on the subscribe option, let's grow the community, and also remember to share the video and remember to like as well. Alright guys. Alright, let's get to it. Unfair Dismissal Award reviewed, right? Procedural unfairness upheld. Right. An employee was found guilty of dishonesty during his disciplinary hearing. He had claimed a call-out fee on 2 separate dates, which should have been paid as overtime, as he was informed ahead of time that the work would be required. So it did not constitute a call-out. And these two kinds of overtime are remunerated at different rates. While the procedural unfairness of his dismissal was upheld by the Labour Court, the substantive fairness or the substantive unfairness was reviewed and set aside after it was found that the arbitrator ignored important evidence against the employee. Right. The case we are talking about is the case between Aspen Pharmaceuticals versus National Bargaining Council for Chemical Industry and others, right? The employee, a maintenance foreman, right, for a pharmaceutical company, was informed by his line manager that he would be required to work overtime on 2 specific dates to inspect a wash bay refurbishment and do whatever was necessary to ensure that the area would pass inspection. Right. The cost order, right, the bonus process. An attorney acting on behalf of the applicant was ordered to pay the legal cost, right, on an attorney and client scale out of his own pocket. The applicant, acting on the advice of his attorney, proceeded with a contempt of court application, even though the arbitration award in question was stayed by the court after the respondent brought a successful agent application. The applicant failed to disclose the full set of facts when the ex parte application was brought, which led to the court issuing a rule nisi, right? Another case, Moka versus Score South Africa Limited and others. The applicant Moka brought an application to hold the respondent in contempt of court, right, on account of their alleged failure to comply with an arbitration award that was issued on the 20th of October 2020. The application was enrolled, right? The application was enrolled to be heard. The application was enrolled, right? Meaning it was given a date of the hearing, right? The application was enrolled to be heard on an ex parte basis on the 4th of November 2022, where after a rule nisi was a return date of 17 February 2023 was ordered. However, on 15 September 2022, the respondents had brought a successful agent application to revive a review application of the arbitration award. The court therefore ordered that the enforcement of the arbitration award issued on the 21st of October 2020 is stayed pending finalization of the applicant's application to revive the review application at the Labour Court. When the applicant's case for contempt was heard on the 4th of November, the applicant's attorneys were fully aware of the order to stay granted on 15 September 2022. The same attorney had acted on the applicant's behalf to oppose the agent application and had filed an answering affidavit on his behalf. The rule nisi ought never to have been issued and was discharged. The only issue left to be determined was that of costs. The respondents prayed for a cost order de bonus proceed straight from the pocket of the representative. That's the term that is used. The court referred to the case of Sainsler, where it was held that there was an obligation on an applicant in an ex parte application to disclose all material facts that could have an influence on the decision that the court can reach. The applicant and his representative displayed a reckless disregard for the full and true facts when they failed to disclose to the court on the 4th of November 2022 the order staying further enforcement of the arbitration award. It is clear that had the court been made aware that enforcement of the award had been stayed, it will never have issued the rule NACI. Section 162 of the Labour Relations Act grants the Labour Court a broad discretion to make orders for cost in terms of the requirements of the law and fairness. The Labour Court held that it does not ordinarily make orders for cost against individual employees who in good faith seek redress against their erstwhile employers. In the present matter, the applicant acted on the advice of his attorney, and the attorney persisted with the contempt application to seek tactical advantage conduct which in terms of the Sandler warrants an order for cost on a punitive scale. The court therefore granted a cost order to deponents propis on the scale between attorney and client. Right. That will leave this at that. Then on Friday we'll be doing another video. I hope you find this kind of information to be helpful, guys. Please remember to subscribe, remember to like, share, comment, share this video on your social media platforms to ensure that it reaches a wider audience. It gets to educate more people about issues like this of review and the cost orders and all of that when it comes to the labor matters. Thank you very much, guys, for tuning in.